Good afternoon, morning, evening, nighttime, daytime, whenever time. Glad you are all here. Hello to Mr. StreamYard, Old Fine Dollars 580, Kim, Toe Cramp, Scott, Mark, the one, Renee. Uh, I mispronounced it again, so I apologize for that. Hope everybody's well. What I'm going to do today is to take you through some legal proceedings and some depositions. And I think the deposition of Markowitz and my kind of impressions of that will be kind of really, they'll give you kind of an idea of why we are here today, I think. Of course, my impressions, my opinions, not legal advice. My whatever I'm saying here today is based upon my participation and view of the depositions and what was asked, communications with counsel, the receiver's reports, my own interactions, etc. I don't have personal knowledge of a lot of these things, so just my opinions and impressions and kind of that, just as we start. So what I'm going to kind of do is go through the depositions, etc. I note, and it's happened on many of the depositions, I know that Mr. Markowitz, I know Oliphant mentioned that something about my channel and had seen it. I'm not bragging, by the way, about that. I find it funny. Markowitz referenced it in terms of the bad jokes. So I know he's at least looked at it. And the last guy who complained about my jokes, whether they be good or bad, and I know most of them suck, but be that as it may, was Doug Fiskew, the guy from the Panthers who had Virtu Capital. He ended up in trouble with the SEC. I don't know how that worked out, by the way, but he did end up with a problem with the SEC, and the NHL fined him for making some inappropriate remarks. He bitched about my jokes, and see what happened to him. And now Mr. Markowitz apparently didn't get the word. He's bitching about my jokes. He said I waste a bunch of time telling the jokes. You know, Mr. Markowitz, I'm sorry. And if you see this today, please like and subscribe, and hopefully the jokes will be better today. So I'm going to just roll on. My girlfriend is so smart. I forgot to bring my phone. We went out to dinner. I forgot to bring my phone. So I used and she wasn't there. So I used my friend's phone to call her. She picks up the phone and says, "What's up, honey?" What a smart girl. She knew that it was me on the phone. Think about that one. Mr. Markowitz, think about that one. What's the opposite of a smart house? A residence. Where do the smart fish hang out? In a think tank. And where do the smart fishermen catch those smart fish? From a scholarship. We're almost done. My friend thought he was being super smart and said onions are the only food that can make you cry. So I shoved a carrot up his. And last but not least, I was speaking to my youngest son the other day, and I said, clearly, remember, son, a smart person always has doubts about something. Only a complete idiot can be 100% certain about everything. My son then asked me, "Are you sure?" I replied, "Absolutely." Anyway, hope you all enjoyed that. And again, those are provided in honor of Mr. Markowitz, who I presume will be watching this. At the during the deposition, he indicated that he thought I was going to be posting this the next day or the night of the deposition. I didn't. I waited. There's reasons why I will, and it'll become apparent somewhere down the future. I'll discuss that. I'm not going to discuss it today because I really can't. but there's a reason why I held off. And anyway, I'll talk about that in the future. So there were, just kind of put everybody in the proper perspective. There's a bunch of depositions that are ongoing. Those depositions are being manned by Dylan Siciliano. He's one of the attorneys for the receiver. He does more of the litigation, the hard litigation. He's been the one conducting all the depositions to date. So there was a move by a former attorney who did work for GTII, Mr. Oliphant, to stop or unfreeze all the shares that were deemed to be disputed shares and to let them be freely tradable. So he filed a motion. Dylan then filed a motion to disqualify Mr. Oliphant, amongst other reasons that he had confidential information, he'd performed work for GTII, and there's a bunch of things like that. And he was also going to represent CYA, I think it's an LLC, that would be Markowitz LLC. I think it's Cover Your Ass LLC. And Mr. Markowitz in those proceedings, but it was on behalf of all the disputed shares. So Dylan filed a motion to disqualify Oliphant, and that was heard. And the court, Judge Williams, before issuing a ruling, he said, there was a discussion and it was learned that there were going to be depositions. And he said, for a complete record, he'd want, if there's any testimony that adds clarity to the issues, then he'd rather that be included so that if it was appealed, that there'd be a full record. Basically, that's what he kind of said. And the depositions were the following week. So the following week was Scott Oliphant's deposition, and that was last week. Well, it's this week. Last week or this week? I don't even know what week we're in. Yes, it seems like it was a week ago. I think it was Monday. And his deposition went on. I believe he thinks, let's just say this. And again, maybe a fantastic attorney, maybe amazing. I just didn't think he was particularly impressive in the deposition, being gentle. I think he was a bloviator who thought that he got paid per word spoken. And, it's funny because he's being deposed, and I'm sure he would tell every deponent that just answer the question, yes or no if he can, etc. And he did not follow his own words. I think he liked to speak, liked to hear himself speak. I don't really think that's an advantageous way of proceeding. During the deposition, there was a bunch of questions about, legal services provided and relationship with Markowitz, etc., because he was friends with Markowitz. And at one point in time, the 144 letter, which is the letter that is issued by, usually by counsel, I guess, I don't know if it could be issued by anybody else, that basically would allow restricted shares given to somebody who provided services. If enough time had passed and they deemed that the services were for benefit of the company, you need this letter and you give it to your brokerage, and then the stock becomes unrestricted, or can be, and then you could sell it. So Oliphant did that apparently for Markowitz, and Markowitz did it for Oliphant, but apparently Markowitz did it for all kinds of people at GTII. And you're supposed to do like a thorough examination to make sure they're appropriate. Now, maybe Mr. Markowitz had a bad day and he couldn't recall what he did specifically, but he didn't seem to have a good recall of the due diligence that he was doing. That was kind of my view of his testimony during the deposition. Anyway, Oliphant has 125,000 shares, or entering the deposition, he had 125,000 shares. I do not know if he sold any before that. I don't believe so. But during the deposition, it was determined that he was promised for his services, and apparently he did two matters. One of the matters was in default, or a default judgment had been entered. I couldn't tell which one because he was, again, a bloviator. But he was talking, and I couldn't tell if it was a default or default judgment. Markowitz engaged I guess Markowitz on behalf of GTII engaged his services. Markowitz apparently couldn't do it because he wasn't admitted in Nevada or wherever this occurred. And by reason of whatever Oliphant did, he was given 125,000 shares. He was promised 50, and then apparently was given 125,000. So that was a big bonus. But during the deposition, it came out that Markowitz got, multiples of the 125,000 shares. It seemed like Oliphant wasn't aware of that. And since Oliphant was doing the work, it appeared, I don't think he was happy that perhaps Markowitz wasn't transparent about the shares. And I don't know if that then fed into the way that Oliphant represented Markowitz in the deposition that occurred the following day. I was trying to figure out why Oliphant represented, and just my opinion, by the way, my opinion, my impressions, and with communications with other counsel, I found his representation of Markowitz odd, unless Markowitz said, I'm going to do this the way I want to, and I'm not going to listen to you and don't object. If that's the case, then probably Oliphant shouldn't have been there. But if Oliphant actually had discretion and could act like a real lawyer, I was really unimpressed by his representation. And again, I was thinking, why would he let Markowitz testify as Markowitz did? And the one thing that I came back to is maybe he was pissed off that Markowitz kind of wasn't transparent about the shares that he got. And in the end, during the deposition, we were a few hours into the deposition already, and there was a break. When they come back, Markowitz agreed to return the 125,000 shares, and he agreed to no longer represent CYA and Markowitz except for the deposition the next day. And I think that was framed on the basis that there wasn't enough time for Markowitz to find another counsel, but Markowitz would have been, in my opinion, would have been much better suited if he had chosen alternative counsel, just the way the deposition went. It's not saying, by the way, that Oliphant didn't speak up at all during the deposition, but very little, and in my opinion, not in spots that were of significance and extremely material and detrimental to his own client. Again, my opinion, based upon what I saw, based upon doing of hundreds of depositions before, based upon situations similar to this that I'm going to talk about. But in the end, Oliphant was clear to say that he was risk adverse. My impression was he got stuck in this. Maybe he used bad judgment getting stuck in this, but he got stuck in this. He's now extricated himself, didn't get paid, is pissed, but he's ready to move on. That was kind of Oliphant. So now I'm going to move on. So that's Oliphant. That's the guy whose the motion to disqualify was filed, but he gave up on that. His shares, he gave up on that. So I would say that's a total concession on his part, complete. It certainly doesn't suggest that whatever the accusations were of by Dylan, and again, I don't know if they were true, but certainly suggests there may have been enough there that concerned Oliphant enough to get out of the case, enough to return the shares. How you want to view that, you can. I view that as he didn't think he had a very strong position, and also he's probably pissed. So I'm going to move on to Markowitz because this is much more important, I think. And just kind of go back. So Oliphant was somebody who represented the interests of GTII. I thought he was very unimpressive. And that was for the benefit, unfortunately, or unbenefit or disbenefit or re-benefit of GTII shareholders. So unfortunately, and part of it is also there was no compensation, appears there was no compensation in dollars. It's always by shares. So that limits the number of the type of attorney that might take the matter. If they're only going to take shares and not be compensated by dollars, you might end up with maybe not the best. Maybe you will, but maybe it limits who the field is that might represent you. So, many times, and I just talked about this generally, based upon the receiver's reports, based upon my own interactions, based upon communications with counsel, I thought that a lot of the material witnesses, they should take the fifth. In other words, not testify in a deposition. Because there's all kinds of claims in the receiver's reports that if they're true, and again, I don't know if any of these claims are true because I don't have any firsthand knowledge. The only thing I know about is my communication maybe with, like Fattel or somebody like that, but he's not involved as a defendant. But everybody else, it's based upon what I've heard, what has come out in deposition, but mostly what's in the receiver's reports. So I don't know if any of this stuff is true. But based upon what I saw, I thought that somebody should take the fifth. And the Fifth Amendment allows you not to testify if what you say might be incriminating in a criminal sense. So it's not a civil, you're not taking it to protect yourself civilly from money damages. What you're doing is you're taking it to protect yourself from any criminal exposure. And, I wasn't throwing it out at anybody particular, but I thought, if what the receiver says is true, then somebody committed, at least the way it looks, somebody committed some crimes besides, breaching their fiduciary duty. And, if you recall from a civil sense, like board of directors and officers have a duty to the shareholders to watch out for their interests. So you could say probably here, comfortably say that duty was not carried out. At least that's what the receiver's reports strongly suggest. But anyway, so I believe that some parties should take the fifth if the receiver is correct, and you can guess who those parties might be. But the deposition of Oliphant went forward, and then the deposition of Markowitz went forward, and Markowitz kind of proudly stated that he was anti-government. He didn't trust the government. I know a lot of us don't trust the government, but he was proudly and openly non-government person. He also indicated that during the course of the deposition that for whatever he did, and I don't know because he didn't have a great recollection about what a lot of the questions. He said he doesn't remember a lot of times. And he suggested that a lot of the stuff happened a year ago, but some of the stuff when he would say he'd not remember, it was within a year. So when somebody says that about something they were involved when, especially when they're a defendant, especially when they're being deposed, because when you're deposed, you kind of are supposed to prepare yourself for what you're going to be deposed on, so you don't answer dumb questions, or you don't answer questions in a way that might hurt your position or would lead to other questions, etc. And you're generally told to answer questions very directly, very narrowly, and not to add additional information. And again, for example, did you walk across the street? And the answer should be yes or no, not yes. And then I went to the market, bought 3 tomatoes, 2 apples, a bottle of ketchup. And a lot of people are violate that rule. So they give way too much information, because the idea is this is not for you to tell your story. This is for the other side, the party who's deposing you, to get information from you. People have like a backwards view of that. But anyway, so at some point in time, Markowitz had apparently, he said 2.5 million shares. I don't remember, because he wasn't clear, at least I didn't get it, how many shares he still has, but he indicates he still has shares. From selling shares, he appeared to indicate that he generated $1.5 million from selling GTII shares. And then on top of that, he got $200,000 out of a transaction that I'm going to talk about that is I'm going to use that as the example transaction. And plus, he said he indicated he got $10,000 from some other, I couldn't tell why, but add that up, it's $1.71 million. So nearly $2 million. I don't know if he got other compensation through other entities, because he really wasn't clear. And again, he didn't remember a lot of stuff. But certainly the 1.71 million arising out of GTII, he was clear about that. So you can imagine this guy who again, very unimpressive, who seemed to be, based upon my opinion, he seemed to have his interests singularly at heart. So, just to give you an example, we're 5 hours into the deposition, and he hasn't mentioned shareholder once. And when he was questioned about did he have a fiduciary duty to the shareholder, because he was called in-house counsel, and he didn't reject that title. I think he was called general counsel too at one point in time in questioning. He didn't reject that. If he's in-house counsel for GTII, he certainly, in my opinion, has a fiduciary duty to the shareholders, but he seemed to have no regard for the shareholders. Again, 5 hours in, hadn't even mentioned shareholders. He seemed to be focused solely on his own personal interest. The fact that David had screwed him once and he would get his, and that Markowitz thought he was entitled to his money. Markowitz thought Markowitz was entitled to his money and he would get it. And that kind of suggested, at least that was my interpretation, that Reichman was getting what he deserved. And that if, he would get a taste of his own medicine. So if he did certain things, it was okay to do certain things back to him, even if they weren't 100% kosher. And as a matter of fact, there was an objection. Oliphant, like one of the things he did, so he spoke up, maybe, I'm exaggerating, but let's say he spoke up 4 times. One of the objection was that exact point. What a useless objection. There's an assertion about kosher, and he tried to define kosher. It really was stupid, honestly. Just again, just somebody was pleased and trying to show his own intellect, but showed the contrary. So we're in there, and Markowitz is talking, and he spent a lot of time about it, and he really did specify that he thought he was entitled to his money. He couldn't really say what he had done, really. I mean, I couldn't see specifically what he'd done. I know he wrote I think he said over 100 144 letters. That include to the Rosie Epstein, that trust, that where the charity got millions of shares, and apparently he wrote a 144 letter making those shares tradable, and it might have been 5 or 6 million shares, but he didn't really know what that trust was about. At least in his testimony, he didn't seem to. His only contact was with David. He had already had negative contact with David. He indicated that David was not trustworthy. In other words, he went to worked with GTII. David screwed him. He knew it. He was pissed. He being Markowitz. He came back later on, and he'd seen all kinds of stuff. And during the deposition, there was testimony about all kinds of things. So he knew what David was. He said that David was a bully. He said that David ran things that nobody could have a say. He said that he bullied Kathy Griffin and put her in her place and wasn't very nice and thought he was the smartest man in the room and that nobody could push back. And in fact, he being Markowitz, justified not pushing back by that David ran things, that you couldn't tell him what to do, that he was the smartest guy in the room, that he had 51% control. That's what he said. And Markowitz justified not doing anything based on that. Now, an attorney has a fiduciary duty to shareholders, as I indicated. So should he have maybe told the shareholders, disclose, if he thought there was wrongdoing or shenanigans going on, and we're going to talk about the shenanigans. If he thought there were shenanigans going on, probably, and this is my opinion, not fact, because I don't know what he knew specifically, because again, he wasn't clear. But if he knew and thought that David was screwing people, not giving them shares that were due, taking monies that were not entitled to, giving shares to officers that they shouldn't give to, not completing audits that they should have, getting downlisted, and if he thought some of that arose to a level of criminality, why didn't he tell? Even if it didn't, probably had a duty to tell the shareholders. probably had a duty to tell the SEC, probably had a duty to tell the DOJ, probably had a duty to tell the IRS, and I'll get into a specific transaction that kind of raises that. And he didn't. I mean, it was pretty clear he didn't tell anybody at any time. And to me, the only reason he didn't tell anybody was because he wanted to get his money. And if that meant the company would somehow, the stock price would go up and he'd be able to sell his stock because somebody would unrestrict his stock, that would be great. Or if he could generate more money, like he got 200 grand, the 200 grand that I'm going to mention. But that seemed to be clearly, he was motivated, certainly by my impression, he was motivated by self-interest and no interest in shareholders, or else within the first 5 hours, he at least would have cussed out the shareholders or referenced it or showed that he could spell shareholders, but nothing. Complete silence. So in my mind, he knew exactly what was going on while he was there at GTII and chose to be quiet about it and chose to leave the shareholders in the lurch and chose to benefit, because he said, this is his testimony, $1.71 million, why the shareholders lost their ass. So is that really justified? And by the way, when the deposition started, I felt sympathy for him. I could see he was under a lot of pressure. I'm sure he did not anticipate that things would go this direction. I'm sure there was no way to figure out that some shareholders would bitch and that a receivership would have been set up and that depositions would come out and that every action that he took while he was at GTII would be scrutinized. I'm sure there's no way he knew that. And I'm sure that caused him an unbelievable amount of stress. So I really had sympathy for him at certain parts of the deposition. I had sympathy for him that he had chosen the counsel he chose to represent him in the deposition. Because we're like 30 minutes in, and it was clear to me that the guy should have not testified. He should have taken the fifth. It was clear to me. It was obvious. And it wasn't just obvious to me, because I communicated with other counsel at some point in time. It seemed obvious and surprising that his counsel was so passive and let him testify. That's why I was wondering if the counsel got pissed off when he found out about the deal on the shares. And this was kind of like a passive aggressive way. He kind of let his friend, because they said they're friends for 15 years. He let his friend look to me like just roast, in my opinion. So some of the testimony again was that Reichman ran the show and that nobody could tell him anything, and he was the smartest man in the room. He thought he was. There was no real clarity as to why Markowitz signed off on all these 144 letters that let all kinds of people sell shares that seemingly, at this point in time, at least some of them were in question. We know Oliphant's were, because he gave them back. So there was probably a lot of question. He did not seem, at least based upon his testimony, to have clear understanding of what diligence he did to determine if the letter should have been written. And now looking at the receiver's reports, I'm sure if he looked at the receiver's reports, his thought process might be different. So, and again, he was in-house counsel or general counsel for GTII. Now, he was not a bar. He wasn't licensed in Nevada. He wasn't licensed in Arizona. Apparently, he was licensed in New York. He went to, and again, he's a great lawyer. Maybe he was the valedictorian of his law school. I'd never heard of the law school. I think it was like Toure, Toure Law School, which I looked up because I'd never heard of it before. I think it's based in New York. I think it's rated, or at least in the most current rating, I think it was rated something like 169 out of 192. So not the top of the food chain, but again, That doesn't mean anything. He could be a brilliant lawyer, and the fact that he went to a law school that may not have been, well respected doesn't mean he could be a great lawyer. I think he testified that he was a stockbroker before that, which is interesting in light of all the concerns we've expressed and in light of how GTII ended up. And I don't know if he has any responsibility for how GTII ended up based upon his experience as a stockbroker. I don't think that was even asked during the deposition, but he might, I guess, but it wasn't asked during the deposition. He was admitted to the bar in New York in 2008. So he passed the bar. Somehow he passed the bar, which is great. He looks older. Well, I don't know how old he is, but he looks old to me. Part of that is he looks really heavy to me. And I was a psych major undergrad at UCLA. Somebody who is that heavy and who engages in the conduct that the receiver claims that he engaged in and that he admitted, whatever conduct he admitted to, and who is willing to fail as many times as he did, and I'm going to address that in a second. It sounds like he's a self-hating person, that he actually hates himself. Because usually, people who let themselves get so out of whack with their weight are filling them up and filling up their hole. Somebody who's willing to be humiliated multiple times, and I'm going to address that in a second. That's my conclusion, which is a sad state of affairs. According to the way that Dylan asked a lot of the questions, and based upon the receiver's reports in his testimony during the deposition, he seemed to implicate, he being Markowitz, seemed to implicate senior management in conduct that Dylan characterized and labeled as criminal. So I don't know whether it's true or not. And I don't, because I'm not a criminal lawyer. I've done some criminal cases, but I haven't done a whole abundance of that. I haven't done any cases involving, money laundering, and Dylan brought that up. I think specifically accused. I don't know if he accused Markowitz directly of committing money laundering. I think what he did was indicated that the transaction appeared to be money laundering, which was a criminal violation. But I don't know, because I don't have any background in that. But there was a lot of discussion about that. There was a lot of discussion about all kinds of documents. There was a lot of discussion about securities fraud. So because of that, because everybody knew that the deposition would delve into areas that might put Markowitz in a difficult position, especially if he was going to admit to the truth of the allegations, that nobody I believe, no one who was looking out for the best interests of Markowitz should have let him testify, in my opinion. And I think that was obvious, and it became obvious as the deposition went on. Now, again, Markowitz could be a brilliant, even though he went to a lower tier law school and looked like he didn't take care of himself and seemed in his testimony not to care about anybody but himself, and didn't seem to even know there were shareholders, didn't even seem to reference to know that he had a duty to shareholders, which is all sad, because that's who was representing GTII. But he was kind of gleeful in acknowledging his bar passage. So he acknowledged that he tried to get, I think, admitted in Arizona, but was denied. And I don't know if it was admitted in a case or he took the bar, at least one or the other. He also indicated that he tried to get, or at least it was indicated before, that he tried to get admitted in Nevada, but he was denied also. I don't know why he was denied, although he indicated that in Arizona seemed to be, I think it was, no, it was in Nevada. Arizona, something happened. It wasn't clear. Nevada, it wasn't clear either, but apparently he filed bankruptcy involving a real estate case, and somehow that resulted in him not be able to get admitted that time or future time. I don't know. And my guess is he followed this logic that a lot of people followed following the 2008 housing crisis, because I was involved. I represented a lot of homeowners 2011 post who had lost their homes, and I saw all the arguments that were going to be made, and some of them used this thing that, you know, a 30-year-old mortgage, people couldn't find the original note, and that was one argument. Then there was this entity called MERS, and they made that argument, but all the judges denied these arguments. But people continued to make these arguments, and a lot of anti-government people made that. So it wouldn't surprise me if his ding that he referenced related to a bankruptcy case involved something along those kind of arguments, although I don't know. So it could be something else, but it wouldn't surprise me if that was the case. But he said he didn't get admitted in Arizona. He didn't get admitted in Nevada. He bought a house. I think he testified that based upon part of that 1.7 million that he got, he bought a house in Texas and now is spending a lot of time in Texas. I don't know if he's trying to protect that asset, and that's why he bought the house in Texas, and it might be in the name of his wife. And I'm sure, and I'm sure the receiver will take a hard line with regard to that. But it sounded like to me, this is the way it sounded like to me. It sounded like somebody was trying to hide and protect his assets, asset protection. And there was some discussion at some point in time about an asset protection vehicle, unrelated to that, but it came up during the deposition. But now he lives in, I think, Green Valley, which is just on the border of Vegas. He works out of there, but he's not licensed in Nevada. But if you look it up, he uses a Las Vegas, I think it's a Las Vegas address, either a Las Vegas or a Henderson address. So someone might say he's suggesting that he's barred in Nevada by using a Nevada address and referencing himself as a lawyer, etc. I don't know, but he's not barred in Nevada, but it looked odd that he was using a local address when he was not barred. Why he wasn't using a New York address, I don't know. But what came up was during, and again, why I thought he was self-hating was his answer. He volunteered that he has failed the Nevada bar 13 times. 13 times. And he says he has the record. Now, why would anybody, unless they hated themselves and loved failing and loved being a failure, take the bar 13 times? I mean, my personal limit is 12. If I try something 12 times and I fail 12 consecutive times, that's where I put my foot down. But somebody who does it 13 times, that sounds like somebody who's a miserable person and hates themselves, and failing is part of his being. So I found that distressing that he was so gleeful about it. Now, just to put it in context, I took the California bar in 1983. I passed it the first time. The California bar at that point in time, and still, was deemed the hardest, along, I think, with DC. And unlike any other bar, when I took it in 1983, it was 3 days long. It's much shorter now. I think the California bar is either 2 days or 1.5, and I think most bars are shorter. And the year, and I'm just doing this to give you an illustration. I'm not a brain surgeon. So I'm just giving you a little background. And anybody can have a tough time on tests. So some people don't do well on tests. But I'm not just basing I'm not throwing this out just based upon his failing 13 times. but it's his glee he took in it, and the fact, the work, what happened here, and his joy and his self-interest, as I see, and what I'm about to talk about when I get to it. So when I took it, it was the first time they did the performance exam, which was basically they gave you two projects to do like lawyers, even though we hadn't been practicing lawyers. And it was the first time they had done it. And it was called the performance exam. And it was the last day, I believe, the exam. So third day, you're just wiped out already. You're tired. And I took a prep, most people take a prep class. You know, they have some value, not a great value. But they said that they warned us. So you get like a 3.5 hour session in the morning and a 3.5 hour session in the afternoon. They said you're not going to have more than one question in the morning or the afternoon, and they'll probably give you no more than 20, they actually said 20 to 30 pages of material to use to do your project. So that would be statutes and cases, whatever. So morning of the last day, they come out, they drop a pack of documents on each person's desk. And I was doing it at the Century Plaza Hotel in Los Angeles. There's probably like 2,000 people in this room. There was probably 150 pages of material. And when you looked at the question, there was 2 questions, I think, in the morning and 3 questions in the afternoon. So whoever prepped us for this had no idea what to prep it. So it was much more onerous than what we had expected. But I passed. And, you know, I do decently on those kind of tests. But I passed the first time. I didn't think it was the hardest test of all time. And my understanding is it's much harder than Nevada bar. So I don't think that Mr. Markowitz should be gleeful about having failed it 13 times. Another example, just to give you another example, is a friend of mine who's now deceased. His sister was brilliant. And she took the bar, I think the same time I did, passed it, and she was like one of the top 10 scorers in California. And California, there's thousands of takers. So when you're in the top 10, that's pretty amazing. And she worked for the SEC in Texas. Her husband couldn't pass the bar. He failed it a couple times, and they wanted to move to California. They got a job in Texas. They were going to move to California, work for the SEC, or do securities in California. He got psyched out. He thought he couldn't pass. So she was 3 months pregnant. She put on a wig, a heavy coat. She covered up her belly. She got a fake ID and pretended to be him, took the exam, the bar exam, for him, in disguise, with the pressure, being pregnant, and she had diabetes. So she would at times go to the bathroom and literally pass out from blood sugar issues. But eventually she went back and she passed. Not only did she pass, but she got like in the top 10 again. And because she got in the top 10, they were suspicious because this guy had failed multiple times. And eventually they were able to determine, because they didn't know, but eventually they were able to determine that she took the test for him. He got permanently disbarred, even though he hadn't been barred, but lost his ability to. She got some restricted, but passed it on to him that he had coerced her and she was pregnant and she was ill. And eventually she, I think, was able to work. But she passed twice in a much more difficult bar. And I don't think she didn't fail it 13 times. So the guy who failed the bar and was gleeful about it 13 times was the in-house counsel for GTII. Is there is it any wonder that we're here now for that reason? And what kind of judgment is it on the point of Mr. Reichman for choosing or doing his due diligence that that should be the person who's running the in-house department of GTII, the in-house legal department. Really, it says a lot about that. When during the deposition, when Markowitz actually remembered something, and again, I'd say most times his testimony was he didn't remember things, he pushed it all back on Reichman. And so if in fact Markowitz's testimony is accurate and Dylan's questions and conclusions and the receiver's conclusions are accurate, then it seems like Markowitz is accusing Reichman of all kinds of misconduct. And if Reichman were to testify in a deposition, I don't know how he would be able to testify without taking the fifth. I mean, he could try. I would just think it would be foolish, just like I thought it was foolish that Markowitz testified and didn't take the fifth. Thought it was ridiculous and obvious and should have been obvious to him and his lawyer. And maybe it was. Maybe it was obvious to his lawyer, but maybe the lawyer told him not to testify, or maybe like I said, maybe the lawyer was pissed. But the problem was Markowitz didn't push back, and he thought it was okay not to push back. He didn't think he had any obligation to push back. It was sad. Clearly, again, a man interested in his own self-interest. So I thought the biggest mistake Markowitz made was showing up in the first place. But last and not least, and here is the rub. Here's the ultimate problem. By the way, so when I say he didn't contact anybody, he didn't contact Markowitz, didn't tell the shareholders, he didn't file written disclosures with the SEC, he didn't file reports that would disclose the issues that he brought up that he didn't talk about. He didn't disclose the fact that he got 200K to the SEC, or apparently did not. Didn't talk to DOJ, didn't talk to the IRS. When he was questioned about $200,000, I guess he wasn't asked about the 1.5, but I don't know if he paid tax on any of that. When he was asked about the 200K, was very unclear. It seemed to me he didn't pay tax, or at least the testimony was very unclear. As to the 1.5, I don't think he was asked, but I suspect, I don't know, but I suspect that maybe he didn't pay tax on that either. But the situation that arose that I think kind of puts it all in a nutshell about why we are in the position we are here and why no one looked out for our interest was the transaction that he described with Tommy Wang, David Reichman, and some anonymous third party. So the situation is apparently, and again, Markowitz's testimony wasn't clear at all times, and he got tired, and his voice went down, and his microphone fell down his shirt. But it appeared to be that Reichman approaches Markowitz, and Markowitz has a company, and Reichman says a third party wants to or is willing to sell shares to Tommy Wang, and apparently it was going to be 10 million shares, and the 10 million shares apparently were going to come out of the profit sharing plan of GTII, apparently, even though there was no profits. And again, if you just heard some of these facts and you were counsel, that should have put a kibosh on anything happening. But he's told that, and then he's told there's a third party that he doesn't know the name of, and they're going to be giving the shares to him, and him being Markowitz, or Markowitz's company. And Markowitz is going to then transfer the shares, or Markowitz's company is going to transfer the shares to Tommy Wang, or Tommy Wang's company. Tommy Wang's going to send $2 million to GTII. Markowitz has already decided and maybe cut a deal. And I don't know if there was a written agreement. I don't think there's a written agreement, but he somehow valued his service at $200,000 at I don't know what service he's talking about. Is it disguising this transaction? Is it making this transaction not transparent? Is it doing business with people you don't even know? What happens if it was like the drug cartel, this third party? Is that okay to do business with a drug cartel without checking? Didn't you know anyway that it was Reichman? I mean, didn't you suspect that this third party was Reichman anyway? But apparently unimportant as long as Markowitz could get his 200 grand out of there. And if you recall, he was already pissed at Reichman because Reichman had previously screwed him out of money thinks he was entitled to. So he's told about this transaction, and $2 million will come back. And I don't remember the order. If the money comes first before the stock goes to Tommy Wang, or if the stock ever got to Tommy Wang. But $2 million comes to Markowitz's company. He takes out apparently 200 grand. Didn't tell shareholders about that. Didn't tell, as far as I know, the SEC about that. He wasn't certain if he reported it to the IRS. I doubt. My guess is he probably did not. And he sends the $1.8 million apparently to David, not to GTII. So as opposed to making sure that money went to GTII, and there's a bunch of declarations that Dylan went over where there's claims that it wasn't for GTII and claims there was for GTII, but I think in the end, it was impossible for Markowitz to disagree with the fact that GTII was a participant in this transaction. And, the conflicts that might exist between GTII and representing an officer and maybe a third party and maybe some outside party versus the shareholders of GTII not stepping in and blocking the transfer of funds to the individual David Reichman as opposed to GTII, not disclosing any of this to shareholders at any point in time until this deposition. So $1.8 million that was supposed to go to GTII, Markowitz acknowledged didn't go to GTII. And $200,000 that kind of went in a circle with a third party that nobody knew about being involved with money coming from an outside source. Looks like, and Dylan was pretty clear about this, looks like money laundering. And he laughed when he said that. I think Dylan repeated that multiple times. I think he thought it was so obvious that it was funny that anybody doing this kind of transaction, it looked so scummy and inappropriate that anybody with a half a brain would know that this type of transaction is not appropriate and will get you in trouble. There were a whole bunch of other transactions that were questioned too. This one where the money was supposed to go to GTII, seemingly, went to Reichman, and Markowitz got his $200,000 cut because David had screwed him before, and somehow he was claiming it was justified, his fee. And he also said that basically that David kind of deserved what he got because he screwed people and bullied them, whatever. No regard for the company. Now I'm referring to Markowitz, but I'm also referring to Reichman, obviously. Zero regard for the company. Zero regard for the shareholders. And zero regard for himself. Why would anybody who had an interest in his own personal well-being disclose this? Why would the attorney let him disclose this? Why would the attorney let him talk about this? Why wouldn't he take the fifth? Why? And I'll just give you an example of a case I was a long time ago. I'm not going to mention a name, of course. Was representing a CPA. CPA had been sued for malpractice. He was an expert, a well-known expert CPA in Southern California. He was testifying in a family law case where there was a dispute as to the valuation. He testified for quite some time, was very credible as a witness, and he gave a valuation. The court used that valuation to make its decision. And in its decision, it specifically referenced the reliability of this expert and his conclusions. Unfortunately, when the expert was testifying, when he was asked, and I don't know why he did this, but when he was asked about the school he went to, he lied. Or he forgot. I should say he forgot. So he made up a better school. So if he went to, like, for example, if he went to the law school that Markowitz went to, which I think is Toure, and I think that's what it's called. Never heard of it. Instead of Toure, he said, I went to Harvard. And as a result, the judge relied upon that. And after the case was over, somehow it came out that the expert had lied about where he went to school. He was sued for malpractice. We were representing him in the civil case because he was sued for malpractice. Very early on in his deposition, somebody asked him, what did you say when you were testifying during the trial as to your school? And he took the fifth. He was advised to take the fifth. And the way it works as to the Fifth Amendment, it's not just the question that you have to not answer, but if your question could lead to information that would lead to another question that could lead to more information, then you've waived the fifth. So if you're being very careful, what you do is you don't answer anything. And so when we were representing this particular gentleman, he was advised not to answer anything from the start. And this was about just him giving the wrong name in a civil case, not what appears to be, at least what Dylan was really, I mean, it was laughable. That's all I could say. Laughable misconduct that any lawyer would know you shouldn't be talking about. And if it's your client, unless your client says, I want to, like, here I go, I'm going to put it on the table and I know what the ramifications are. Unless the client tells you that, I think you got to advise him to the contrary. And I was, again, shocked that he said that. And I think he's got, I was shocked. And the fact that he didn't look out for shareholders, the fact that he thought it was okay to do this, the fact that he didn't think he had to speak up because he knew, he suggested that David taking the money, that wasn't right. So he knew it. Did he tell the shareholders? No. Did he tell the SEC? No. Did he tell the OTC? No. Did he tell the DOJ? No. Did he tell the IRS? No. Did he tell Sergeant Schultz? He told nobody. Why? My speculation is he thought if he tells anybody, not only might he get in trouble himself, but he won't get his money. And again, my view was nothing was paramount to Markowitz other than getting his money. And that was, in my opinion, what seemingly, based upon his testimony, seemingly controlled his actions. And, if he would have disclosed everything and if he would have acted above board, if he would have called out David, because he was in a position, remember, he didn't disagree that he was in-house counsel and or general counsel. For that, I think he did a miserable job. And I don't think he took out, my view, he didn't take care of the shareholders. I don't think he took care of the board members. I don't think he took care of anybody other than himself. And I don't think he was obscure about that in his deposition. So I thought his testimony, I felt sympathetic to him. I felt his stress. I felt like he was surprised he got that. But I thought he was disgusting. An absolute disgusting POS. And he, in my opinion, I think he just screwed all the shareholders. He was in a position he could have called everybody out and stopped this, but he elected not to. clearly. I mean, his testimony was clear. He was aware of all kinds of shenanigans going on, even if he wasn't involved in some of them. He was aware of them and chose not to speak and had no excuse for not speaking. None. So this is somebody that David Reichman chose to be his house counsel. So is it any wonder, based on that choice, that we're here now? And whatever happens, I hope that the Receivers Council makes sure that Markowitz keeps none of his shares. And to the extent that he's gotten any money, I think it makes sense to go after whatever he has. If that means going after that Texas property, if that's what it means, because I don't know, because Texas, part of Texas and Florida, part of the benefit they offer to a lot of debtors or prospective debtors is they let you protect a lot of property. It might be the reason why he bought the house in Texas, because maybe he's going to file a bankruptcy and protect his house. I don't know if the government can take it over, if there's tax fraud or something like that. I don't know. And I don't know about those 144 letters, all those letters where it didn't seem like there was a ton of due diligence that was done, although I don't know personally, but it didn't seem like there was a ton of due diligence done. But I don't know, because I don't know what Markowitz and Oliphant talked about to prepare. I don't know what they agreed to. I don't know what Markowitz told Oliphant what to say or not to say, or whether to object or not to object, or whether Markowitz just decided, I'm just going to put it out here and I'll accept the ramifications. I do not know. But from what he testified to, I wouldn't be sleeping well. I would not be. And I don't think he did a very good job, to say the least. And I think he really had an opportunity to protect us, and he chose not to. His testimony seems to implicate others. Again, if what he testified to, because think about it, the transaction it's coming from an unknown party going to an intermediary party, going to a third party. It's supposed to go to a fourth party, but instead it goes to a fifth party, with the intermediary giving himself personally, I think that's how it worked, or accepting personally, not in the entity, although I'm not sure. Maybe the entity is the one who got the money. No, but I think it was through a trust account. So I think it must be, although I don't know. I have to say I don't know, so I'm speculating here. But we know that the money certainly went like 5 different parties, was going all different directions, and the person that was basically coordinating it didn't know who that party was. And he testified about it. He didn't know, and it was unidentified, and he didn't think that was a problem. So he didn't seem to think like if that was the drug cartel or the mafia, if you were getting money from them or stock, you don't have to find out. He seemed to think that was okay. I thought it was ludicrous, but again, doesn't surprise me that Reichman chose somebody like this to play it out, because he could benefit by finding somebody who wanted money more than wanted to protect investors, because he didn't protect investors. He obviously did not. The audit. So the audit, somebody asked me about, so that's the deposition. So I've kind of gone through it. I used just one example, that one transaction from originated by Reichman, from a third party to an intermediary to a fourth party, back to the third party to Reichman, as opposed to GTII. No disclosures to anybody that would be meaningful. And there's tons of other transactions that were referenced, but that's the one that seems to be the most problematic in so many ways, that Markowitz didn't seem to argue against, and again testified about. And I was amazed amazed that he testified. If I was his counsel, I would have told him otherwise. I'm going to touch on two quick things. The audit, they think it's far along. They still haven't specifically identified it. I've asked Dylan to have a representative of the auditor present on the 14th. There's a hearing on January 14th, 2024, a status conference. I've asked him to have some representative there. If you're interested in that, perhaps you'll send a message to the receiver asking for same. I know that there's a group, and I've mentioned this before, that are trying to put together a group of shareholders, and I know there is a group already, but trying to put together a bigger group of shareholders to have Nevada Council kind of represent them and have their voices heard. If you're interested, please reach out to the group, and I'm sure they're on here today, and I see them on X, but please reach out to them, provide whatever assistance you can to them. But I've asked that somebody from the audit be there. Whether they are, I don't know. It may be that the receiver would take the same position, that they don't want to disclose the date, and maybe they don't want to give the information. But I think it's an appropriate amount of time based upon the fact that the September 2024 order from the court appointing the receiver suggested that the audit would be done in short time frame, and now we're a year and 3 months out and still no audit, and we should have it. There's no reason not to, and we need the audit to move forward. I believe that it's close in hand, but I think we should get an explanation from the horse's mouth why it's taken so long, and some idea when we could do it. There'll be a deposition, I think, on the 17th of an attorney named Brooke who left David's employ. I think my understanding is he might have got frustrated. So I think that might be interesting in terms of the explanation about why he left. And I think there's still negotiations ongoing amongst the parties. I think some of these depositions might give leverage to the receiver's counsel to use against these parties in negotiations. For example, if I was negotiating with David and I just heard Markowitz's deposition about that $2 million transaction and the dark third company, etc., I might use that and say, that suggests you have liability, civil liability, if nothing else, and that, you're, in terms of negotiating, it might take a little leverage against Reichman if he's trying to keep shares or trying to keep money or anything like that. So that's what's going on. And then after that, there's the hearing on January 14th. So there's a deposition on the 17th of December. There may be some other matters that come up. If other matters come up, I will report on them. I wouldn't be surprised, but I don't know. And then after that, there's the hearing on the 14th of January, and that's the next event. So I have talked about Oliphant, his representation of Markowitz's deposition, the receiver's report, my opinions, etc. That certainly didn't seem to me had the interest of the shareholders at heart in any respect. Didn't even mention them by name 5 hours into the deposition. But I think it was very valuable and will be very useful to the receiver, I'm sure. If you have questions about this, let me know. Reach out to those people that are working on the council in Nevada. If you have questions for me, to reach out. I will bring you up to speed on the deposition on the 17th about the attorney in Brooke, because it'll be interesting to hear how what he says about Reichman in the depositions. Anyway, hope that I wasted a lot of your time here. I hope the information was interesting. I found the deposition very interesting. We will talk to you soon. If I don't talk to you before the 17th, have a good week. That's next week anyway. But have a good rest of your weekend when it comes. Be well, everybody. Take care, and talk to you later. Really, that's what we're going to say.